Well, if you want to start with just the level of bribery, of course, Chicago has a great deal of expertise in that field.
Champion.
Pardon?
The world's champion.
Right. Well, nobody seems to be trying to compete with us for the moment. It has been a serious problem in the court system in Illinois, particularly in Cook County. I think the problem really stems primarily from the fact that we have an elected judiciary in Illinois. And Illinois, of course, everything is very highly politicized, including the judiciary. And so the types of people who tend to ascend to the bench, or have in the past, have produced, not all, of course, because like in any area, most of our judges are fine, but compared to other areas, a high percentage of people who've been easily tempted and have been taking bribes. We had 18 judges, I think, convicted in the last scandal that the U.S. Attorney prosecuted. Then we had people thought that was going to put an end to this, and then a few years later we had a follow-up scandal where a number of judges were indicted and some resigned from the bench. And
you know, Marty, in 1981 I was involved in a case in a federal court. And the client, we were losing some early motions. The case ultimately involved lots and lots of plaintiffs and a $750 million judgment for steel companies and so on. But we were losing some early motions for a small client, and he asked me, he said, "Do you think this judge is on the take?" Federal judge. And I said to him, "There is no way. This does not happen in the federal courts. This is heresy. Don't darken my door with such a suggestion again." In the next 10 years, 3 judges were convicted or indicted for taking bribes. 3 federal judges were convicted or indicted for taking bribes.
Well, it is unusual in terms of the number of judges. I think that a very small percentage are on the take. But look, one of the things we have to remember is that the judiciary is made up of human beings. So to some degree, people who get to the bench are going to reflect the population as a whole. And as much as we would like the process of judging to be based on the civics lessons we learned in school, that everything is honest and based on the facts and the law, a certain amount of human frailty is going to be there. Particularly with the judiciary, for the reasons that I think we've talked about here, of how important the courts are, we ought to be working hard to minimize that, even compared to the other branches of government, for 2 reasons. One, judges serve either for life or for a long time. It's much easier to get rid of a crooked legislator through an election than it is a crooked judge. And 2, because they have so much power over our lives. So what we ought to do, and I guess we're getting ahead to the dessert a little bit, is work on a system that out of the whole population of human beings who have these frailties, we tend to select people who are less likely to have them. In an elected system like in Illinois, where judges come up through being precinct captains. Really, it used to be. It's better now. One of the famous statements, and this should clarify for everybody, that came out during one of the judicial slate makings in Cook County, where the Democratic machine really controls the bench. A few years ago, the party had decided to allow these slate making sessions to be open so we could hear what was going on. And one alderman, who's also a very powerful politician, got up and said, "I am for so-and-so to be slated as part of our slate. This person will be terrific. He will be an alderman's judge." And he got slated and was elected. And that was the most important thing that could be said about him. So, when that's the selection process, you're going to have a higher percentage in other places of people who are going to be found being corrupt.
So would we basically agree that it's not a widespread problem? It happens, and when it happens, it casts terrible dubiousness in people's minds on the judiciary.
We ought to if I could just, I hate to dominate, but there is a story that just happened in Chicago that I think is so unique, it should be fascinating to all of us who practice law. There was a mob hitman who hit somebody, killed him with a shotgun, back about 20 years now, and went to trial, chose a bench trial, which he had the option to do, and the judge was paid off. I think the bribe was $10,000, and in the face of an eyewitness who got on the stand and said, "That's the guy," the judge said, "acquitted." So the hitman was freed. The judge was subsequently investigated by the U.S. Attorney, and before he could be indicted, committed suicide. Years later, we had a new local prosecutor elected who decided to re-indict the hitman. And the hitman defended it, went all the way to the U.S. Supreme Court, arguing this is double jeopardy. I was already acquitted. And the Supreme Court said, this is so fundamental to our system, there could not be double jeopardy because you were never in jeopardy the first time because your judge was bought. Right. And they allowed it to go back, and the case was just retried a few months ago, and of course now the same eyewitness fortunately was alive and he was convicted. Right. But that's unusual. Usually when you're the victim of a bribed judge, you're stuck. Your case is over.
This excerpt is brought to you by the Massachusetts School of Law, the leader of reform in legal education and a leader in multimedia education for the public. To view the full interview and for a full listing of MSL's programs, log on to mslaw.edu.